I think there's a general view that the protection of rights is within the exclusive preserve of the courts. In other words, it's left neither to the citizens, nor to the parliamentary process, nor to the public at large to protect rights. And that's a matter that should be left first and last to the courts. I think that's a view that we need to rethink. And the reason for that is that courts don't always or don't necessarily protect rights. And my book includes several examples in which the courts have failed to do so, where the courts have abdicated their responsibility or avoided their responsibility to protect rights, but where other institutions have stepped in and done so. And just to give you an example, one of the cases that I discuss in the book is the Kartar Singh case. And this is a case where TADA, which is an anti-terrorism statute from the 1980s, is challenged. And what happens in that case is that the court takes a long time to hear the case, about 9 years to hear the case, and following that period actually upholds the legislation. And it's in fact the public consensus that results in the legislation not being extended shortly after the court's judgment. So what I say in that case is, it's not because of, but in spite of the court's judgment that rights are protected.
In your study of not just the cases that you have articulated or profiled in the book, but in your long study of the law, why do you think the courts have so frequently been behind the curve, whether it is in as standout occasions as the emergency or in individual other such legislative situations, such as, for instance, the TADA or other cases?
I think the simple answer probably is that it's easier. It's institutionally easier for the court to be behind the curve. And the reason for that is when the court is either in step with public opinion or is behind public opinion, its decisions are easier to implement because it's decisions that the majority agrees with. On the other hand, if the court goes further than that, if the court takes decisions which are ahead of the curve, which are not necessarily in step with but are leading public opinion, those decisions can in fact be harder to implement. So in some sense, it's the convenient path to take, but not necessarily always the right path.
But what distinguishes then our judiciary from our politicians?
Well, our judiciary is inherently meant to be counter-majoritarian.
But yet it isn't. When it comes to upholding rights, let's say in the case of an emergency-like situation or otherwise, it never has proven to be, or it has very infrequently proven to be counter-majoritarian. So what distinguishes today our judiciary from our politicians if the judiciary prefers to either stay in step of majority opinion or just a step behind, but never actually take the lead?
So that's one of the concerns which I articulate in the book. I think it's fair to say that there are some areas where the court does lead public opinion from time to time. So free speech is one of those where you might say the court is fairly progressive in its decision-making processes.
Okay.
But there are other areas where the court is either in step with or behind. And let me give you a couple of examples. National security legislation is one of those classic examples where you might say the court tracks public opinion or is behind public opinion. And if you were to look at national security cases over the decades, if you look at POTA, AFSPA, TADA, any of the statutes on national security that have been enacted, the court's decision has certainly been one that is consistent with the majority view, if you like. That's one set of examples. You can also use another set of examples, cases on gender, cases on personal rights, if you like. And there was an opportunity for the court in 2013, and I'm talking about the Section 377 case, to at that stage you might well say lead public opinion. The court failed to grasp that opportunity. And 5 years later, the court did in fact overturn its previous decision and strike down or read down Section 377. Now what happens in this 5 years? You might well say that what happened was that public opinion itself changed. And therefore the court was now acting in step with public opinion.
Can I interrupt you? But in
Yes.
2013,
Yes.
the Delhi High Court was ahead.
Yes.
and it was the Supreme Court that actually fell behind, wasn't it?
Yes, that's absolutely right.
So I'm trying, I know we look at the judiciary, especially the senior judiciary, which is the High Court and the Supreme Court, as one sort of mass whole, right? But you know, the standouts have been not judges that have not respected fundamental rights, but those that have actually stood up. They have been the few and far between, whether it's an H.R. Khanna from the times of the emergency or an A.P. Shah from 2013 or from the Delhi High Court. The broad bulk of Supreme Court senior judiciary or High Court senior judiciary seems to be behind the times. So, I mean, this is a thought that I've often grappled with, saying, why is it that the one body built constitutionally to protect us, has so often failed to do so, whereas in the design of every other institution that makes up our democracy, that failure was sort of weaved in, that failure was anticipated, right? The court was supposed to be the bulwark that sort of protected us from all of this, and it just hasn't worked out that way.
It's interesting you use that example, because my book also includes several cases where the High Court judgment has been more progressive
than the
Supreme Court judgment. And the Supreme Court has in fact gone ahead and restrained the High Court, if you like, and changed the High Court's view. It's hard to know why that's the case. We have so many examples of this. It's hard to know why that's the case. But one reason might be that the Supreme Court is somewhat more conservative because it's conscious that it's the last court of appeal. I mean, this is very much a function of our own appellate structure, where the expectation in all significant cases is that an important matter at the High Court will almost certainly be appealed to the Supreme Court and will be decided by the Supreme Court. So perhaps where the High Court can gain some comfort is from the fact that it is not the final opportunity, it's not the last throw of the die, whereas the Supreme Court is. So that might be part of the explanation. I don't think that's a good enough explanation, but that might be a rationalization.
Okay, fair enough. Yeah. One of the other things, Chintan, a lot of people understand the Supreme Court's supremacy through the saying that, the Supreme Court is not right because it's final because it's right. And you've gone on to, in your preface, to make the other point that this book seeks to dispel the myth that courts have the final word on all the questions that arise for their determination. Explain that to me and tell me why you believe they don't have the final word, and why we must understand that very clearly, because in this country today, almost every time we're let down by our politicians, we look towards the courts for rescue, and we are so often disappointed. Sure.
So the reason I say this in the book is that I think the broader public understanding of the legal system is quite linear, in that the legislature enacts a law, it's then up to the government to implement policy and to implement the law, and it's the court that makes the final decision about the constitutionality and the legality of both the law as well as the government's implementation of the law.
Right.
Now, I think viewing the legal system in this linear way is far too simplistic. And in each of the cases that I've analyzed in this book, what you'd notice is there's in fact a iterative process that takes place between all institutions, between Parliament, the government and the courts, where the court's decision is merely part of the process rather than a culmination of the process. So you have several cases where, following the court's decision, the government takes a further decision, and that decision can involve a number of things. It can be a constitutional amendment to overturn the court's decision. It can be a number of steps that the government decides to take in order to sidestep compliance with the court's decision. So what you see very often is formal compliance on paper, without complying with the judgment in spirit. It can also be a review petition. Remember, a review petition is something that the government itself, it's a step initiated by the government in order to seek to overturn the court's decision. And so I think it's rather simplistic to say that when the court decides a matter, that matter is final. As a matter of practice, that's simply not how things turn out.